All right, guys. We are live with Justice Watch Live here. So, this is my nightly show I normally do in the traditional live. So, if you found me in my vertical mobile, this is, I will normally do this late at night, although I've done it early too. But today we're going to feature the Tucker hearing. He had a 12-minute status hearing today. We're going to watch it, then we're going to talk about it, and then I'm going to redirect you to his interview, which starts about 6:30 over at Excited Utterance. So you can hear from him on exactly what his thoughts are. So we're going to watch it together, and we're going to get our thoughts together. Hopefully, more people will come in. If not, we'll talk with Among Us. So identify yourself in chat as we're watching, and then we'll get to watching this. So let's give me a moment here. Let me get it queued up, and then we will begin watching. All right, guys. So here we go. We're going to go ahead and queue it up. Start watching. He is appearing via Zoom, so he will not be in that courtroom. But if you're looking in the courtroom right now, you see over there that's Prosecutor Mansfeld, who's actually in court. This lady over here sitting at the defense table, she's not related to the case, and the judge is right up over in the right-hand corner. With that said, let's start watching.
Tucker, Mr. Tucker is appearing via Zoom. Mr. Tucker, I can see him now on my Zoom call. Let me do this. Give me a moment.
Hey, Jeff, how you doing, man? Thanks for coming over.
All right, there's Mr. Tucker. We have Mr. Mansfield appearing
And
on behalf
Chris,
of the state.
awesome to see you here, man. I hope you're still in there. Thank you for watching with us.
I put everything that comes through my chambers on for an arraignment docket to properly calendar going forward. Mr. Tucker's case was a result of a recusal by Judge Jones. The case came to me. I had made last time we were here certain disclosures that I believe were required. And I wanted for a certain time period to go by so that Mr. Tucker could process the disclosures that were made, so that he could make a decision whether or not he wished to file a motion for disqualification. Mr. Tucker, have you filed a motion for disqualification? Okay, well, the name is escaping me right now. Perhaps Mr. Mansfield can.
I guess we can't hear Mr. Tucker's side.
Mr. Tucker or anyone, but there's a name that is given to an agreement wherein a defendant who has been provided disclosures by a court and has been made aware of information that would ordinarily be used in a motion to disqualify a trial judge. And the defendant, then knowing that information, would sign an agreement. Does anyone know what the name of that agreement is? Sorry, Judge, I don't.
It appears I don't think he knows how to get his own volume up. Well, I mean, or at least not for us to record. Because I think he's recording, he's screen recording this.
Tip of my tongue. The point is, it's essentially an agreement where the defendant says, I am aware that this judge previously was employed by the Office of the Public Defender at the exact same time the Office of the Public Defender was representing a co-defendant in my case. I'm aware of the fact that I could file a motion that the court cannot pass on the facts alleged and is almost essentially required to be disqualified or enter an order of disqualification. So if I find what that is, I will certainly let you know, but that would be the court's preference going forward. So, Mr. Tucker, the reason I'm taking up all the time right now, though, is despite this, I still have not made my final decision whether I'm going to stay on the case. I'm going to put this on the record now, and I want you both to pay very close attention. So in light of all of the disclosures that I've previously made, and in light of my own inquiries into this matter, I haven't found authority that is consistent with someone in the position that I'm in, being required to recuse themselves, with one major and very, very important exception. Okay, and again, I wanted all of this to be on the record. I am at this very moment waiting on one last inquiry before I make my final decision that could come as soon as this afternoon. And I just wanted to note for the appellate courts, if they read this, I am keenly aware, and I'm going to read in the record now, Florida Judicial Canon 3E, that's 3 as in echo. It says under subsection 1, a judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might be reasonably questioned, including, but not limited to, so for the purposes here, including instances where, let's look at subsection B, and I'm going to break it down almost word for word here. The judge served as a lawyer or was the lower court judge in the matter in controversy. That is inapplicable to me. However, after the comma, it says, or a lawyer with whom the judge previously practiced law served during such association as a lawyer concerning the matter. Again, we have Travis Johnson was the defendant. The matter was Mr. Tyrone Tucker as one of the co-defendants, and Mr. Travis Johnson was the other co-defendant. And while Travis Johnson's case was pending, he was represented by the Office of the Public Defender of the 16th Judicial Circuit by attorneys Mr. Kevin McCarthy and Mr. Jason Smith. At the time Mr. Travis Johnson's case was pending, I worked in that office. My office was, as I've mentioned before, very close to Jason Smith and very close to Kevin McCarthy. I've already made all of the disclosures. Despite all of that, I performed nothing related to Mr. Travis Johnson's case. I knew nothing about it other than that simply the case was referred to as the Treehouse murders. I never participated in any intra-office discussions. And if you've worked in that office, you know that there was a lot of them about almost every case. But in this particular case, I did not participate in any of those. Be that all as it may, I can't help reading the plain language of this judicial canon, which says the lawyer with whom the judge previously practiced, there was two of them, served during such association as a lawyer concerning the matter. And they did. And it doesn't provide any caveats there. It just says basically, if you were a law partner, which is what the public defender essentially is, we're all lawyers, working for representing essentially the name of Robert Lockwood then at the time. That's the issue. It seems to me that the plain language there would require and not make optional my recusal from the case. Again, I found no other authority though that makes it so clear other than what my eyes read from the page. And so Mr. Mansfield and Mr. Tucker, I'm letting you know, you should not be surprised if I ultimately conclude that my recusal is proper under the canons, okay? That's why I have not made a single ruling in this case. And that's why, even though Mr. Tucker, you wish apparently at this time for me to stay on the case, it may be out of your hands. Do you understand that, sir? Okay. So, I hate to do this, but I'm going to have to, take a few more days to have my final answer to you all, because I know there's so many outstanding things. The only thing that is for sure is that I've properly advised Mr. Tucker that there were certain timelines for the retrial of this case. The state has indicated they were prepared to go to trial. Mr. Tucker has affirmatively waived his right to that trial in that time frame under the rule. He's affirmatively demanded a continuance of this matter. And do we have any other date for this case? Yeah. Okay, I'm gonna have to set a date for the next hearing, sir. And I'm gonna, just like I do to the attorneys that appear before me, I'm going to hold myself to a timeline and give you a final answer no later than the next date that I announce in just a moment. But before I do so, and while I have you, Mr. Tucker, at this time, I wanted to remind you, and I'm gonna give you a stern warning here. Because if I do stay on the case, you need to be mindful that all of the previous orders of Judge Jones, they remain in effect until I rule otherwise. Those orders, they remain in effect. And again, related to the cautionary advisement, sir, you were about a day away from getting a no bond allowed warrant when your electronic ankle monitor turned off. Okay? Do you understand that if I receive another notice of that, you will be incarcerated indefinitely until the conclusion of your trial?
Unfortunately, we're not going to, I guess, be able to hear Ty's responses, but that's not good. That was the motion that I picked up on, I believe. I reached out to Ty to try to see if that's what it was. I believe that's what it is, where his battery died. He's been having problems with it, and it prompted him, I think, to file a motion. No, there's plenty of other choices, Jeff.
Ink on it, and I thought better in light of learning of the circumstances that I've disclosed to you, instead of ruling, I would go this route. But I'm telling you, sir, don't let that battery go out. So anyway, sir.
So I don't know if that's recent or not.
Follow all orders unless another successor judge undoes those orders. I have undone none of them. And I don't intend to until I provide to you all a final decision as to whether or not I'm going to stay on this case. And as it relates to that date, that a final decision can be expected. And this is also because I think there are some.
No, you were correct. It's Judge Jones.
Account for Mr. Tucker's potential request to move me off the case. Sir, I'm looking at my calendar now, and I will have a final answer for you.
He might want to go ahead and file that request. I don't know. It seems like to me like this judge is saying that the only reason why he didn't issue the bond revocation is because he hadn't ruled yet. So instead he decided, I'll give you one more chance to say, hey, don't have that turn off anymore, and then we'll deal with, because remember, Tucker has a motion to amend his bond conditions, which I don't know. There's something about this judge. I'm not all high on this judge.
I don't know if I have to explain myself.
I don't like how he jumped on that with you're 1 day away from a no bond request.
April 16th at 1:30. You can appear via.
I mean, it's nice that he didn't do it
today. Come on, we may talk for a minute or up to 5. Okay.
Wow. So what do y'all think, chat? Jeff, Chris, if you're in there, I think we got a few others. Identify yourself. Tell us, what do you think about the hearing?
My links have not changed in 2.5 years. It will be this Zoom address.
Okay? I'm thinking Ty was late. That's what it sounded like, possibly.
Okay, we do have the jail up, so I'm kind of going back to the beginning of the docket. We have Iran Lazo Gonzalez, 22 CF 152.
I'll leave the interpreter.
So I think that's not a good. That was not necessarily a positive hearing, in my opinion. That's concerning. I mean, that's very concerning with the way the Judge Jones bent over backwards not to look bad, given Tucker's accusations in his pro se status. Well, yeah, he did. Well, he bent over not to look bad because he knew he was under fire of looking like he was going to be covering something up. This judge, this is what I've said from the beginning. This judge was brought in for a far different reason. He was brought in because they felt like I think, to allow for the state to allow for this guy to be hard on Ty without looking like he's biased. That's what I think he was brought in. I think he was brought in basically, and he said it in the last hearing. I don't know if you guys watched the last hearing, but he said it in the last hearing that, look, when I set a date, that's it. And if you want to continue to represent yourself, then, I'm going to tell you what you need to do, just like he was instructing him on exactly what to do to file the motion. But he's supposed to file this motion to recuse. And it's procedure wise because essentially he has the right to file it. I guess he's supposed to file it, and then the judge will either deny it or would either deny it or grant it. And he hasn't filed the motion to recuse yet. So the judge is doing all this on his own, which shows this judge is fair. How you doing there, Southside Memphis? Welcome to the chat. So, it's that does show he's fair, but it's concerning nonetheless because he's talking about revoking his bond. I think the way this judge is going to operate is, he's going to, like, for instance, in the last hearing, Ty waived his speedy trial too quick, in my opinion. That's my opinion. I don't think that was the right strategy. Yet he hasn't filed his motion to dismiss yet. That keeps him. That was a way that this judge or any judge that wanted to see their way out of it, that could have been a loophole way that nobody has to admit fault. Remember, they keep wanting to give him a no contest. All the prosecutor would have had to do was not be ready for trial, or this judge can't get himself. They can't get the scheduling done. He files the motion. If 60, I believe it's 60 days or 90 days. It's either 60 or 90 days. I guess it would make more sense 90 days, but I believe it's 90 days. And if he isn't retried within 90 days following a mistrial, it's automatically dismissed with prejudice and or without prejudice, and meaning it can't be refiled. And this judge explained that to him, and he said, "I'm going to waive." And he jumped right in and said, "I'm going to waive it. I'm going to waive it. I'm going to file my motion to dismiss." The motion to dismiss still hasn't been filed. The last hearing, I thought I heard the judge say the 4th was the deadline, but I think that might have been the deadline for him to file the motion to recuse. That might have been what he was talking about with Ty. I'm not certain. These hearings are kind of hard to hear. But it's concerning nonetheless, because if he would have had that in place, it would have forced things to roll forward quicker. And then essentially it would have forced this judge to make a decision, and it would have forced to decide whether or not this judge wants to stay in the case or not. And Ty seems to, I think, be operating under the belief, well, I want this judge. He's fair. He's this, he's that. Well, listen, if there's a conflict, now, with him being a public defender, here's the thing y'all probably didn't know. Judge Jones was a public defender. But I think that, I think that he should have waited, because he could have at any point asked for the continuance. In other words, he could have filed a motion to dismiss, and then that could have been handled inside of that. But if the motion to dismiss never got filed, or this judge can't, has this problem come up where, again, it sounds to me like this judge was saying, listen, in the last hearing, he was trying to get Mr. Tucker to understand this. If I recuse myself and I get out, it is up to the court system to find you a judge within time. It is up to that judge to get up to speed on the case. And that clock keeps ticking. If for some reason they can't find a judge to retry the case and that time clock runs out, Ty Tucker's case gets dismissed without prejudice. What he was trying to say is a lawyer would have played that game and said, no, we're not, we're ready to go, Your Honor. And they would have set it all the way up until they weren't, because obviously if a new judge comes in, or if they have a hearing that they need to get through, they're going to have to deal with it. And then Tucker can say, well, you know what? I filed this motion to dismiss, Judge. We're ready to go. I will, and then he could file the motion to continue and make his waiver. But he should never have given it up that early, especially when no motion to dismiss has even been filed, and it's not even clear that the judge is going to consider the motion to dismiss. So it's very premature for all that. Didn't Tucker state he was going to file a motion 4 or 5 times during the trial, but never did? I don't think he really knows how, and he's married to the notion of going pro se. Does he really know? Yeah, well, he said he was going to during the okay, so Jeff, just to clarify a few things, what he said during the trial was he was going to file a motion to recuse the judge, in other words, or disqualify the judge. He was upset with the judge's ruling. So what he was going to file at that time, that was a motion to disqualify. The motion to dismiss was already argued last year. What he is going to do, since he has a new judge, is he wants to file, since there's a new judge in town, he wants to file a motion to dismiss. And the reason why he's waiting on a transcript, which is what he says is delaying the motion to dismiss, but I say, listen, if you already know what it is, do what they did to you in the motion in limine. Just simply put in the information you believe is there, and then if the judge decides, hey, we need a transcript, well, then that's on them to provide the transcript. If the transcript hasn't been provided and there's a deadline, you want to do this. You want to just go ahead. You don't want to, you don't want to defy the judge's deadline, because that's going to be the excuse he needs to say we're not going to consider this thing. On top of that, he's talking about a 100-page motion to dismiss. There are certain standards that a motion has to meet, that the judge can actually say, it's too many pages long, it's too long, it doesn't have this, it doesn't have that form. And it's a very, so to me, there's a lot that's going on with that isn't guaranteed. See what else we have to say. Chris Diaz says, yeah, I'm not high on this judge anymore. No motion for dismiss. Why 12 more freaking days when he said could be this afternoon? Weird dude. And also, congrats on 17K. Crazy how fast you're gaining subs. I was an OG. Laugh out loud. I know. Well, hey man, it is crazy. It was, I'm doing the putting the content out, the shorts, just hitting it every day, and then I got the nightly mobile streams have gone bonkers, and I've just it just seems to be building. Like I said, we were at like just under 4,000 subs on February 28th. That's a day, obviously, that marks in my mind, because that was the day before my dad died. My dad died on the 29th, and I don't think it's any coincidence. He leaves and goes upstairs, and next thing you know, it just all channels blowing up. And within 3 days, I'm monetized, and it was just nuts. So just blessed. It's crazy, but we're going to lean into it, because, like I said, the point of the channel is to get attention to things, and the more people, the more subs I get, the better, because that means when I talk about a case, or I bring a case, or I broadcast a case, more people are going to see it. Yeah, thank you, Chris. I appreciate it, man. Very much so. Jeff Pogue says, I'm not a fan of Ty. I think he's married to pro se due to ego, when a lawyer could have gotten him off. He couldn't get his star witness on. A lawyer could. He couldn't get his witnesses there. Well, here's the deal, Jeff, on that. First off, I don't think he's necessarily married to pro se. I think you got to understand there's a few things you got to understand about the circumstances that led him to pro se. Number one, I think that he should consider now. I think he achieved all his goals as pro se. So I think, but I'll tell you a story in a minute on what happens, and I think it's kind of can happen when you get in there, right? So, but first, let me explain to you why Ty, at least to my understanding, from having talked to Ty, interacted with Ty, and listened to Ty in other interviews. So, what he explained to me was, when the original motion to dismiss was denied, he got upset and frustrated because they were under a gag order. So the reason why he originally went pro se was to beat the gag order, because he couldn't speak, he couldn't get things out. He felt handcuffed. He felt like they were pulling and they were sealing everything. Remember, so that motion, that gag order, which I'm still in the middle of broadcasting, all the story around that. But when you understand how that gag order worked, you see that thing was just an iron clamp on information, and it was covering up everything. So what he wanted to do, he realized the only way he could speak was through filings. So what he wanted to do was be able to file motions like motion in limines, motions to disqualify, and include things that lawyers couldn't, because lawyers are required to have a certain to do things at a certain standard. As a pro se defendant, he can pretty much do whatever he wants. They can't take away his law license, and he's facing life in prison. So, I mean, what are you going to do to him? So the way he saw it was, I'm going to jump in here and I'm going to file these motions. And what he was really trying to do was just get the word out, get some attention on this thing. Well, he wasn't even certain he was going to do the first trial without attorneys. But what happens is he finds out that John Travis Johnson might be in the wind, that he might be out using again and unable to be found. They're not even sure if he's alive. So as a result, this got leaked to Ty's advisors, and they said, get your butt down there. Trial is scheduled. And, because at first Ty was going to file, the goal was Ty was going to go take on Judge Jones and file a motion to disqualify and just put all the dirtiness in there. And you have to remember, the whole reason why Ty ever got bond was because he wrote a letter to the judge. He took it on himself. And he wrote that letter to the judge, and it got things out. So he was like, I'm going to do it again. And then once we get rid of Judge Jones, he was thinking he might bring back his attorneys. Well, issue at hand is they find out about this John Travis Johnson deal. Well, John Travis Johnson is the only witness in the case. He's the only evidence they have. So when they get the wind that, hey, maybe John Travis Johnson isn't in town, and if he's not in town, well, geez, that means they would have to go to trial with pretty much no evidence. And then when they would get to judgment of acquittal time, it would be an automatic judgment of acquittal, JOA, and it would be done. So they advised him, get down there, don't do the motion to disqualify, because if John Travis Johnson truly isn't available, you want to take advantage of that. So he shows up. Well, it turns out, guess what? That was a lie. They had basically put this information out through channels that they knew would get to Ty Tucker, and they baited him into coming in and trying the case alone. It's hence why he didn't have his subpoenas in order. He didn't have his case in order. He didn't know anything about procedure or anything like that besides, what his attorneys were trying to teach him on the fly down there in Key West. On top of that, it's the first time he's been out of his apartment, out around the public, because what does the judge do? He lifts the gag order. And also, of course, he lightens the release conditions, because when he's down there, he's got to be at a hotel. He's got to be out and about, and he's going to be allowed to go out and eat lunch at, during court. So the conditions were all, so it's like, here he is. It's like sensory overload. So you were seeing a whole combination of that he was just like, first time he's able to talk to people about his case, first time he's out and about around people, and that's what he shows up with. Well, when they get down there, of course, it goes, well, you saw it. But what it did do is it brought the attention Ty wanted. And Vinnie Politan and Law and Crime and various different news organizations all started paying attention. The internet became a fire. I found him. I was just, I was very small at that time. But, other true crimers have found his case and are now talking about it. Crime Circus has found the case and put it out to all of his supporters. So now that brings us to today, and that brings us to what Jeff was saying. Now is the time to bring the attorneys in. Everybody's watching. Everyone is aware. Everybody knows his case. Now, if you listen to Ty, and again, we're going to go over and listen to him here in a little bit. If you listen to Ty talk, he has indicated he might be bringing his attorneys. He has not at all told me whether that's true or not. It seems he's going to go it alone from he and I's discussions. He seems confident that he's going to be able to file a motion to dismiss and be successful, especially as he's adding from the motion in limine, which, as I talked about in a subsequent show, the motion in limine is very troublesome. They lied in a motion in limine that they just filed, and it's borderline. I mean, it's not even borderline. It's these prosecutors for lying. The judge may not acknowledge it, but if the judge were to acknowledge it, that could be grounds to get the case thrown out. That was a bad motion. But absolutely. Well, Jeff, the thing is I think what he also wants too is he wanted to bring attention to what's been happening to him, because there's other people. Listen, you have to understand, if you followed my coverage of the case and what I've uncovered in the case, there's bad people. There's bad things happening down there. He is not the only one. This was listen, if you understand and I don't know if it came through clear in everything that I had said in my when I put my shows together. Why they prosecute? It's 5 hours long. A lot of people didn't watch all 5 hours. Probably went a little too long on it. I should have broke it up, but I didn't. But the bottom line is what I found, and again, my dad, being a defense attorney, dealt with the same task force that is dealing with Ty Tucker, and I know what they're capable of. I know what they're willing to do, and it's called the high intensity drug trafficking. It's a high intensity drug trafficking area task force. That is what the Monroe County. That is where this case begins and ends as far as what was going on with the case. The lady that set this whole robbery up was a key informant for HIDTA. It's why HIDTA was on the scene, and HIDTA was the head of HIDTA at the time was Penny Phelps. Pitcher, if you look at his notepad, it's HIDTA. Those letters are on his notepad that he's taking down notes from. What happened is they were worried that if Anthea Clay went down for this, that it would jeopardize 4 major cases that they had just filed. But that they had just filed. And that is the key here. That's why they wiped Anthea Clay clean. It's why Phelps goes on the scene. Now the thing is, Phelps. Now there is. If you go back, and I haven't talked about all of this stuff because I haven't got into it yet, but there were early motions filed, and there's hearings that I have transcriptions of where they were talking about the potential, and Judge Jones essentially threw it out and wouldn't let him get into it. He said, no, I'm not going to make him turn it over. But there is potential informant files on John Travis Johnson, which again, it was always weird why they treated John Travis Johnson as they did, because everybody on the island, if you go back and you watch, everybody on the island of Key West at that time, the days after, that was around Paula were saying it was JoJo, it was JoJo, it was JoJo. JoJo was back in the area. JoJo was hanging out with Rory, and JoJo and Rory did this. And as you know, Todd O'Quinn sees JoJo, who he picks out of a lineup. Now Todd O'Quinn is scared. He says this in subsequent interviews. He was scared of these people. He was scared because, this is who he runs with. This is his circle. You're not going to go snitching on people. So he's not comfortable. But he said, he even pointed out, this guy looks like it could be him. But he said he recognized him. When he's describing the individual that he sees pull the mask off with poofy, a little poofy hair at the top and cropped hair, kind of crop tight hair going down the sides. That is John Travis Johnson. Connor, excuse me, guys. Sorry about that. It's my son. I got to get him out of the room. I apologize. My little one likes to try to come into the room, into the streaming room, and get on air. But anyways, he wants to, he was afraid of them. He knew that he knew these guys. Rory, who he said recognized him, and he recognized Rory. But John Travis Johnson, he was hanging out with Paula. He was around. And remember, Paula's telling Pitcher that JoJo, that she heard it was JoJo, that people had called her and told her it was JoJo. So they know this. He knows this. So you have O'Quinn saying, "Hey, that's who it is." So the question is, why do they ignore him? And Pitcher knew this, and Pitcher, but they still pursue Ty because when they go down to T-Mobile, he's the one that walks into the T-Mobile store, and he's the one paying the bill. And I guess they, even though it's 3 days later, that's who they start to go after. And then they look at the picture of him, and he seems to be the convenient one that they can go after and say, well, that's who it was. And the main problem that occurs here is when Phelps goes in and decides, she decides the way this case has to be done. If you go in and listen to those interrogation rooms, she actually discusses exactly what her theory is. And she goes in and she says, we got to close this case. The key is the white guy. So the way they figured it is get Rory to turn on the white guy, who she assumed was Ty. And once he turns on the white guy, right, Rory becomes state property because he's making a deal. The white guy goes down for the murder, right? He's the one that they wanted to put the knife in the hands of. And now those two guys are shut off. And now Anthea Clay, guess what? Rory gets the deal because Rory's the one that met the people or met with Anthea or was told about the whole thing. So they wanted to give Rory they wanted to give Rory the deal to shut him up, and then the white guy goes down for everything, and ain't nobody listening to him. And then Anthea Clay is okay, and she's safe. And as she was sitting there taking care of cats as part of some cat program for the Monroe County Sheriff's Department. That's what they were angling at. And then it got all busted up when the tapes came because the tapes showed that a truck arrived. And a tape show, and then there was CBS. So you have to understand this too. There's missing tape in this case. And that's another aspect that Ty Tucker can utilize, but he's got to understand how to do it. So to get back around, Jeff, yes, this is the time, and that's what I've been trying to tell him. You've got to, these are complicated motions that a lay person and a pro se person isn't going to necessarily know how to apply this. So you've got to get attorneys in because this case with an attorney properly handling all of this now would absolutely kill this case. Now, the problem is, as I was getting around to tell you the story, my dad used to help people out with pro se quite a bit, pro se defendants. He was involved as part of his story, and he would get people to, part of what he would do with them is help them file their own motions up to a certain level. And then the agreement would be, now you hire an attorney. Now you get an attorney involved. And a friend of mine was involved doing just that. And my dad worked with him, and he went to court, and he had some success. And guess what? He got overconfident and decided he wanted to try to handle his own defense. And he learned the hard way when he went into a contested hearing, and it didn't go well. And then he did ultimately end up hiring an attorney to get his case worked out. But the point is, I think that's in a way what's going on with Ty, because I think he's feeling confident because of the outcome that he had. But I think that the outcome that he had, while it is what you've seen in the motion in limine, they're coming at him, and they're going to come at him in a different way. And they're going to try to tighten this case up. They're going to try to focus on the fact that the blood was on the knife. I was thinking about this today, earlier today, and I'm worried because they're going to be coming with a story. And when you're a juror sitting in that box, and the way they're going to present this case, and you're not going to have Paula in there, you're going to have them delivering a transcript of Paula. I have a feeling that John Travis Johnson might not even make it back to the retrial, and they're just going to use his transcripts. I think it's odd that they wanted Tucker and Johnson's transcripts. That's the only two transcripts they wanted. Plus, they wanted the transcripts of Paula's testimony. So I'm like, I think that's what they're going to do. They're going to bring Paula's testimony in, although the whole testimony has to come in. They want a portion of Tucker's testimony to come in, but they can't do that. He has the right to have the entire testimony presented to the jury, including his denials and explanations. Like I said, I'm a little concerned because I think that's going to be what their whole case is going to be built around, which is how did he know that the blood was on the knife? They're going to try to keep the police statement out, and by presenting, which obviously, if you put the police statement in, it explains exactly how he knew the blood was on the knife. But he's not going to care. He's going to go. He's going to go and they're going to push forward and argue to the jury that how did he know about the blood? You've got Paula is now going to be, hey, they're going to use the inference that, isn't it funny how all these witnesses began their testimony saying A, and then now they're saying B, and not to mention that she really doesn't have any testimony to offer. So pretty much any testimony she was going to give, remember, she never actually got in. All they ever got in was the deposition. And then they're going to put in the same inference that says that she was bought off. And then, like I said, it's a case that a lawyer would pick this thing apart in 2 seconds. But if Ty gets in there and gets emotional, gets upset, and doesn't stay on point, and doesn't focus the jury on reasonable doubt, and doesn't explain to the jury how they're supposed to process the case, and leaves it to them, could be disastrous. Anyways, with a lawyer, this dude gets no attention but gets freedom. A lawyer destroys Johnson. Points out no time. That's exactly right. Gives a coherent opening and closing. This dude out. He's anonymous. This dude is out. He's anonymous, but he's out. I think they're dirty down there. But if I'm Ty Tucker, I'd rather be freed and right. Well, no, 100%. I agree with you on that, Jeff. But the Tom Thumb video is a big deal because see, if Ty and if as long as Ty understands how to do all this and gets everything timely filed and gets everything in correctly, the Tom Thumb video becomes his way out, and that is under the Sakalumi case. He is entitled if they are in possession of evidence that could be exculpatory to the defendant, and it gets lost or destroyed while in police custody. He is entitled to. He is not just entitled. He's entitled for the jury to receive an instruction on that evidence that the police were in possession of it, and that they are to presume that the evidence that would have been on that tape, had it been played for them, would have been exculpatory for the defendant. In other words, if the allegations that Ty is alleging is that it would have provided him an alibi or it would have proved his innocence, then that instruction goes to the jury in regards to the Tom Thumb case. You add that in, you get a lawyer that's going to be able to bring in remember, there's the motion to suppress that Travis's attorneys filed, where Travis claimed that Phelps coerced him into his testimony and said that all the testimony he provided to the court was a lie. On top of that, you have the IA report that can come in through the business hearsay exception by getting the custodian of records in, and they can bring it in and they can say, yes, in fact, this is exactly what, why the motion in limine was so bad, or what they did with it, because it wasn't that there was that there was evidence that was tampered with. It's that it was mishandled. It's that you've got all the evidence in this case, the physical evidence, the clothes, cell phones, records, data, all of it was not properly stored and was missing for days at a time. Thereby, anything that the state brings in should be looked at with skepticism and should be doubted. And that is called reasonable doubt. So you bring in the IA report, reasonable doubt exists right there on the investigation itself. You can't trust anything that came out of the investigation. You know, Jeff Pogue says, exactly, but Ty doesn't know how to get this stuff tossed. That's exactly. He wants attention more than freedom. He couldn't get Paula in because he wasn't savvy enough to tell her how to turn up the volume on Zoom. Well, that, and then also remember she somehow got given drugs, Xanax, I believe is what they turned out. She was drugged. Jeff, I don't know if you knew that. They gave her Xanax that morning, which she wasn't supposed to have. That's part of the other issue that they had, was that it was working perfectly okay. And then the state has their people over there, and the judge should have instructed those people from the state, the investigators from the DA's office, they should have had to go in and help with the camera. But they use the idea, well, she's sick. Well, you're over there. I mean, put up a suit and get in there. Send somebody in who knows how to handle the stuff. I mean, Ty Tucker can't go over there, which is why he said he needs a good paralegal. And that's true, he does. I mean, he needs somebody there to help him with. But what he really needs is just hire the attorneys. Hire the attorneys back, and that would be great. With a lawyer, they have tech at the hospital. Absolutely. They would have somebody over there. It would all be set up. In fact, they would have probably went in and deposed her after hours with a video camera and had the prosecutor there, and they'd have just done that with, in some form or fashion. And, or they may have just decided to use the testimony that they already had. That's probably what it was. Again, remember, one of the reasons why Ty got rid of the attorneys, in addition to what he wanted to do, was because they were wanting to present a case focused around the doubts in the case. And he wants to out this case. He wants to out the corruption. And that's what while that is a noble cause, you don't do any good to the cause if you get convicted, because then they win. So the first thing you want to do is win. Then go in a civil suit, get your civil lawyers, or else handle your civil suit yourself and go in there and sue their pants off and out this whole thing. And guess what? The media will be all over it. And he got the benefit of, like I said, right now he has the benefit of the exposure he's already gotten. Give me one moment here. attention more than freedom. Yeah, dude needs to call Aaron Nelson in Wisconsin. I agree with you. All right, let me switch rooms here. Give me a moment. All right, guys. So, all right, Jeff. So, looks like I think it's you. I think it's well. There's two other people that have come in with us. Appreciate you too, man, Jeff. I appreciate you coming into the lives and talking and keeping it live. You got great insights, and this is what it's about. This is why I wanted to. This is why I wanted to do this, because I'll tell you, when I was investigating Ty, some of the comments I got on some of my videos really helped. Uh, you know, get the thoughts going and get things moving. So what we're going to do now, without further ado, it's 6:50. Ty's interview, I think, is about 20 minutes in. Let me see if it's up. But I'm going to redirect us over to Ty's interview on Excited Utterance. I don't want to take away from them. I don't want to stream it out of them or anything like that. I want them to get full credit for it. So, we might stream it later, but if we want to talk about it or react to it. But there it is. Yeah, he's on there. So let's get it over there. They're watching the interview. You guys can probably hear it pop up. So I'm going to go ahead and end this. I will be also at the same time. It'll redirect you to Excited Utterance, so you don't even have to worry about searching it up. And then we're going to be going live tonight. I'll be putting up soon the vertical live, and I'll be on in and out from there, talking with everybody, talking about the new case, and go from there. So let's end this thing, guys. I appreciate all of you that came in tonight. I think it was like 52 of you. It was kind of a on short notice live. But we will be rewatching. I'll probably, as I promised everybody on the vertical mobile lives, I'll show Ty Tucker tonight as well. So anyways, we'll go from there. All right, guys. Until we talk again, let justice prevail. And I appreciate everybody. And I'll talk to you soon.